I'm now going to turn it over to the managing member of our Orlando office, Alan Schwartzide. Alan, take it away, sir.
Thank you, Jeff. Let's see. First, let's make sure. There we go. All right, we're actually sharing. So as Jeff mentioned, I am the managing partner of our firm's Orlando office. We also have offices in Palm Beach, in Pompano Beach, which is in Broward County near Fort Lauderdale, as well as Tampa and in Miami by appointment. So, pretty much anywhere in the state, if you need help with a community association issue, that is literally all we have done since the 1990s. There are 20 of us as attorneys, a lot of staff as well, but we all practice in this area. We've got 8 board certified attorneys that are allowed, according to the Florida Bar, to call themselves experts in this field, and one that's also that type of expert, board certified in construction law. We also address a lot of county and circuit court mediations, including through my office. I just did 2 of them last week that are just literally trying to get the parties to get these community association issues resolved. And we do take that into heart. Although we provide aggressive guidance towards our clients, we also are capable of kind of seeing the other side on things. And that also helps us preclude some of the arguments that we think might be made, or at least address them. So if you don't have counsel, if you're not already working with our firm, as Jeff mentioned, during the survey later, please feel welcome to check off that little button that says, please do contact me about potential association representation. If you got any questions, you need to reach out to us. Happy to hear from you. But in the interim, here we are talking about conflicts of interests. This is the class about what you need to know about those conflicts. And we're happy to present this class for your education. I want to clarify, this is not legal advice today. So if you need specific legal advice, if you need to supply that advice to your members or to the rest of your board, your manager, please make sure that you get that from your attorney. And again, if we aren't your attorney, you're welcome to reach out to us to make that happen. If your community ever needs legal representation, we hope you'll think of us. Now that I've given a little spiel, I will not talk very much about our firm anymore. I'll talk about the materials that you guys actually came here to hear about. And so today's agenda of what we're going to talk about, if my slides actually work, there you go. So just a brief industry overview is what we'll start with. Then we'll talk about what a conflict of interest actually is. I'll talk through some statutory regulations, including some that are coming up in July that haven't kicked in yet in HOAs. What the directors are obligated to do, some warning signs of what to look out for as to, hey, this might become an issue going forward, how to manage that risk, and then finally some best practices of how you can maintain your community in the way that will avoid some of these conflicts and avoid some, potential crimes and damages according to Florida law. So one of the big points I want to make before we even really get started in earnest is that a conflict of interest is not always a bad thing. And I say this during every board certification class and every time I talk about conflicts. It's not always bad. You might get a great deal if the person that you're working with is the president and director's cousin who's going to give you a $2,000 discount on your landscaping for the month because of that familial relationship. Doesn't mean you can't work with that entity, but there are certain disclosures that are going to be required, and the director is probably going to have to step away from the discussion and voting on that. All right. So what I want to focus on today is the limitations on what that individual with a conflict is allowed to do and the fact that the conflict needs to be disclosed. Those are the 2 places where people tend to get themselves in trouble the most, is not mentioning the conflict, sometimes, frankly, because you don't even know that it qualifies as one. And then also stepping in and really pushing that relationship between the conflicted individual and the association and the vendor. Those are the 2 things that you really need to focus on to make sure that you avoid some of these conflicts. So I mentioned that we're going to get into some stats. These are a little outdated, but unfortunately, CAI has not given updated ones that I was able to locate. This is as of 2016 and 2017. I am 100% certain, given some of the communities that we have represented over the last 5, 6 years, 7 years now, that there are definitely more communities, more residents, et cetera, than what's shown here. So I want you to be clear that when we talk about some of the things that need to be done, like Jeff mentioned earlier, you've got your new, in a condo, you've got your new reserve studies that are going to be required in the next year or 2. Those are all things that are very much impacted by these numbers, because the more communities you have that need to get these things done, especially in Florida, it says 48,000 associations. That's one of the biggest in the nation, if not the biggest. We have more community associations than anywhere else in the country. So obviously that's going to become a big issue when you're talking about trying to find vendors for those types of reserve studies, and frankly, for anything else that associations need done. So the other thing to keep in mind is, while we have increases here because of those reserve issues, you might also see some more condo terminations coming up where communities just can't afford to do the maintenance they're required to do. So just keep all this in mind. This is not crucial to today's webinar, but we did want to kind of give you an overview of, hey, this is a big issue in Florida, because let's say there are 48,000 communities in Florida. I think there's probably more like 49 or 50,000 at this point, but let's say there's 48. Okay, let's say 1% of those communities are the ones like you hear about in, I think it was the hammocks in Miami and some other places that you've heard about, people stealing money, doing business with family members and not disclosing that interest, and potentially even getting kickbacks for it. The more communities there are, the more likely that that stuff is going to occur. Now, I want to be clear, that is not happening in the vast majority of communities. So we're not here today to badmouth community associations. We're not here to say, oh, this is rampant, it's happening all over the place. It was back in the day, but it's not quite as bad as it used to be because of some of these statutory regulations that we'll talk about. But I do want to be clear, the more communities you have, the more likely that 1, 2, or 100 of them are going to see some issues with respect to these conflicts.
So I found a 2020 statistical review from CAI National. So I went above the chapter level, and it shows 351,000 community associations, and HOAs account for between 58 and 63%, and condominiums account for 35 to 40%, with cooperatives 2 to 4%.
Thank you, Jeff. Appreciate that. So hopefully that's helpful to everyone. And again, I think that would probably generally likely result in another 1,000 to 2,000 of those community associations in Florida. So let's move on. What is a conflict of interest? That's really what we're here to talk about today. What is self-interest? So these are some definitions that we want to get into. What are we actually talking about when we say you've got a conflict of interest? One's personal interest or advantage, in other words, something that you benefit from, especially when it's pursued without regard for others. So self-interest is basically, you don't care how it impacts somebody else, you're going to do what's best for you. Now, keep in mind, as a director, as an officer, it's not necessarily explicitly mentioned here, but you have a fiduciary duty to not do what is in your self-interest, and in fact, to do the exact opposite if that means that what is in the association's best interest is better than yours. You have a duty as a director, as an officer, as a manager, to put the association's interests way above your own. So even if it hurts you, even if this self-interest would say, I got to do X, but the association would benefit more from Y, you got to do Y. So we talk about self, a person, could be their family, business, or some type of ownership that creates this conflict. A conflict is literally a contradiction or a disagreement between these two obligations, the obligation to yourself versus the obligation to the community. And then we talk about an interest. That could be a share, meaning a corporate share, any rights, a title to property or to amenities, and then just cash. So a conflict of interest is a circumstance that impacts a person whose personal interests might benefit from official, and that means as a director or officer or manager, from those official actions or influence. In other words, me being on the board enables me to benefit from this, even if it doesn't help or hurt the association. This is what we're talking about. That's a conflict of interest. How broad is that definition? The conflict exists whether it's real, in other words, it's current. I'm actively promoting this business that I have an interest in, that the association might have a contract with. Potential, it may happen given circumstances, or might not happen, or it could just be perceived. There's no actual conflict, but the members seem to think that, well, you know, I can get into some examples later on, but this is where someone is a realtor that's not doing any deals that have anything to do with the association, but happens to sit on the board. Well, can a realtor sit on the board? That's a conflict of interest, isn't it? Not if that realtor is not doing any deals that the board oversees. So that's one example of that perceived conflict. It's not real. It's not even potential. The only potential is if that director that happens to be a realtor was selling property and then also got to vote on whether or not that sale was allowed to go through, or whether the association was going to have some kind of right of first refusal kick in or reject a potential occupant or a potential buyer. That's a conflict. The fact that the person's a realtor and happens to be on the board and might sell a property in the community, if there's no right for the association to screen buyers, is completely irrelevant and no conflict at all, in my opinion. So this is the stuff that we're looking at. These are perceived conflicts. They're not real, they're not potential. People think they exist, but they don't. Now, that doesn't necessarily mean that it's not an issue, but you may need to be transparent in the fact that, listen, we understand there have been rumors regarding this director happening to be also a realtor. We want to be clear, there's no conflict of interest because we don't have those rights to screen occupants. We don't have rights to screen people that buy in. So that director doesn't get to vote on whether or not that's approved. In other words, that director doesn't get to say, yes, my sale is approved and the other guy's sale is not. Or my renter is approved, the other guy's renter is not, etc. So it's where this individual might actually benefit is the only time that we have a conflict. Now, that individual could be an entity, it could be something else. We'll get into that in a moment. But I just want to be clear, a perceived conflict should be cleared up with the members, but is not a conflict. How broad's the definition? The relevant self-interest can be direct. Direct is, in other words, that person gets dollars or gets title to property by virtue of that deal going through. Okay, that director, that property manager, that officer is directly receiving a benefit because that director owns the landscaping company you're thinking of working with and directly gets dollars through that company for the association working with that landscaping vendor. Okay, then we can have indirect. Indirect is, well, it's a relative, a close associate, a really good friend, a regular household member. In other words, someone that actually lives with this board member. Immediate family, obviously, is going to mean a spouse, partner, child, parent, or sibling. The Florida statutes in some instances also include grandparents and grandkids and uncles and aunts. That's not technically immediate family, but it may be considered for purposes of a conflict. So don't think that just because they're not on this particular list, these are examples. That's what EG means. Okay, these are examples. They're not exclusive to anything else. And then again, close associates could be an indirect relationship, which is a friend or relative, a business associate, or a rival or enemy. This doesn't have to be a benefit to the individual. It could be that you're hurting a rival, hurting an enemy. Okay, so it's something that impacts, not something that automatically is a benefit directly to this person. Indirect is literally to anyone else. Okay. Now, a private interest can be pecuniary, which means you're getting dollars or you're getting property, or non-pecuniary, which is a non-financial benefit. In other words, you get prestige, you get something else, or it can be a mixture. It can come out of a lot of different types of personal or professional related sources and relationships. So when we talk about pecuniary interests, just so that you guys understand what these interests might be.
It would be like mixing cigars and cash, right?
That is a very good example.
Just curious.
The cigars and the cash could both be something that someone obtains either from an employer or from another person. If that director is handing out the cigars or cash or getting the cigars or cash, that would be a pecuniary interest. Okay, non-pecuniary would be, well, this is something that it's not money and it's not goods, it's not necessarily services, but down the road, it's I'll help you out, or this will help you out, this will improve your chances of X down the road. Okay, that's usually what we're talking about non-pecuniary, but we'll get into that in just a minute. Again, pecuniary, it's an actual potential or perceived financial gain or loss. Money doesn't need to change hands. That pecuniary interest exists if the board member or this other person owns property, holds shares, investment, or other business interests, has a position in a company that's bidding for the work. Again, these are all ways that this individual could gain financially from the contract or the service agreement that we're talking about, or from the purchase of goods. It doesn't have to be a service agreement. Other ways for pecuniary, receiving benefits such as concessions, discounts, gifts, hospitality, holds an office in the other entity. That's another way that you could get pecuniary benefit, because obviously you want to keep that office in the other entity. And when I say an office, I mean director, officer. Has any other relevant financial interest. And examples of these, you can get some benefit discount or avoid an expense. And this includes where we see that the association hires a contractor to repair all of the roofs, and that contractor happens to go into the director's unit and do some additional repairs for free. No charge. The association's not paying for it. But it might have influenced the fact that the association decided to work with that contractor because this director was getting the free goods or the free services. Okay, that's the type of thing we're talking about. Another way is if you're a beneficiary or trustee of a trust that might end up giving you some benefit, or you're entitled to receive income or services from whatever that relationship that you're contracting might be. Now, we talk about non-pecuniary, and I said I would get into some examples. That's what we'll do here. Okay, that can be from personal or from family relationships, involvement in sports, social, cultural activities. Basically, this is your buddy that you're working with. Okay, it includes a tendency towards favor or prejudice resulting from friendship, animosity, or other personal involvement. In other words, it's not a financial benefit, but you get to help out your buddy who you're working with, or you get to hurt the person that you really personally don't like. You've never had, business dealings with them, but that's John, and John's son is getting all the play time on the field, on the baseball field, and your son is so much better at shortstop and really should be getting to play all 9 innings. And you know what? Because of this, you just hate John. So John's not getting that association contract. That's what we're talking about here, or at least that's an example. Okay, if personal values are likely to impact the proper performance of this duty to select the best vendor, not just the one that's going to help you personally the most, that can also lead to a conflict. So again, examples, we talk about self-dealing, where a director or officer enters into a transaction that benefits them directly, often to the detriment of the company or the association. This is sometimes usurping corporate opportunities. In other words, the board gets title to a unit at a substantial discount. Okay, a director of an HOA, because a condo, I don't believe you can do that at all. We'll talk about that later. But an HOA director just buys property from the association, and it's worth 150 grand, and they buy it for 50. Well, that, unless there are some other circumstances that make that acceptable, it's probably not, because it's probably self-dealing in a bad conflict. Non-monetary compensation is another one. This could include physical items or non-tangible items, which is services or perks. We're talking about taking someone out to Ruth's Chris, taking them to, come visit your facility in New Jersey when you are sitting in Florida with a Florida Community Association. Non-tangible benefits can also include status, reputation, recognition, etc. We talk about confidential information. That can be used for your own advantage too. What we talk about here is, well, I happen to know that we'll be willing to underbid this company, and so we're intentionally going to bid just $1 less, whereas normally we could probably cut, another 50 to 100,000 off the price. We're gonna cut 2,000 off, knowing that we're still going to be the lowest because I'm related to this entity as a director. Jeff, did you want to step in?
A couple of questions this happens quite often, and I'm just curious where this fits in. All right. So let's say you already have a vendor, you already hired the roofer, you already hired the paving contractor, whatever it is. They happen to own a suite at the stadium for all the Dolphins home games, and they invite people to use the suite where, how does that fit into any of this as a no-no?
I'd say it's a questionable. If you're already in the contract, then technically that was not, the ability to use that suite wasn't necessarily due to the willingness to contract. But keep in mind, there's still a concern for a conflict there.
Yeah.
Because, and by the way, guys, Jeff is just throwing this at me just like you will with the Q&A. So don't think this is scripted. I'm just kind of thinking on my feet here, but my concern with that one would not be necessarily, although it's a little bit concerning, the fact that, the contract is already in place. I think that reduces the risk that you're signing the contract as a result of kind of a pay to play type of situation.
Right.
But the concern I would have is, well, what about a year or 2 years from now when that new contract is up and they're expecting you to remember that they took you to that stadium and that game or to concert in their, their skybox. That's where I have a concern, is that unless you are 100% certain you're not using that contractor and not re-signing with them in the future, there's still the potential for a conflict, even if we were to say that, the post-contracting is not an issue.
Yeah.
I think the pre-potential contracting is still an issue for the future.
Okay. Thank you. Just curious, because that's something that I've heard of quite a bit.
Yeah, and again, the reality is whether that's a real conflict, I don't know, but it's certainly going to be perceived as a conflict.
Perception.
Members, and that perception is actually pretty important. Whether or not you might get in trouble legally for what you're doing doesn't impact whether or not you might be voted off next year because people think that you're skimming off the top, so to speak. So just things to keep in mind. But yes, Jeff, excellent question, and definitely a real life example that we've all seen playing out. So I appreciate it. So again, let's get back into the non-pecuniary. We got family interest. You got nepotism. Your child is hired. Their contracting firm is hired just because of their relationship with the director or the officer. That can also involve unfair distribution of gifts. So we're talking about, let's say the manager happens to be a director officer, former director officer, or the child, or one of these family relationships. The fact that you may end up paying them more in salary. It's not just whether you contract with someone that can be an issue, it's the contract price as well. And this is talking about direct employment potentially. And, whether you're giving them additional benefits that any other manager might not get as an association manager, or that, you wouldn't have to pay if you hired a management firm, which is generally a good idea. Okay, so let's move on. The more clarity, transparency, and this is what we're talking about with perceived especially, and consumer protection, to provide more of this stuff, the Florida legislature enacted restrictions effective July 1st, 2017, only in condos. So those restrictions that are still in place now say that these are things that you cannot do. The association can't hire the same attorney who represents the management company. That's why we represent and work with, let me clarify. We work with a lot of management firms. I don't believe we represent any, and that's to avoid this potential conflict where we wouldn't be able to represent your community in addition to your manager. Okay, a board member, this is another one. A board member, manager, or management company cannot purchase a unit that's foreclosed as a result of the association's lien, and can't take title by deed in lieu of foreclosure. So this is what we talked about earlier. Again, this is condo specific, doesn't apply to HOAs. So the other thing that I see come up that is a perceived but not a real conflict is where a director is going to bid at the lender's foreclosure sale. That's not a problem in an HOA or condo or a co-op. If a lender is foreclosing, that is not an association sale, there's no conflict, because let's be realistic. Unless they happen to also work for the lender, in which case it's a conflict with the lender and the association couldn't care less. There's no information that this person has that was gleaned from the association's records that this director, officer, or manager has special access to, that they could have used for their benefit to purchase this property for less money. Okay, so you can't, and in a condo, a director, an officer, manager can't buy property at the association sale, but a lender sale, a tax deed sale, a construction lien sale, all of that is fair game. Okay, and this is continued again regarding condos in particular. We've got some statute numbers here just to help you guys out if you wanted to look them up. An association can't employ or contract with a service provider that's owned or operated by a director, or with anyone with a financial relationship with a director or officer, or a relative within the third degree of consanguinity. That's where we were talking about grandparents, grandkids, uncles, aunts, etc., and siblings. Keep in mind, this doesn't apply if the director, officer, or relative owns less than 1% of the equity shares. Candidly, I don't know where that parenthetical comes from. I didn't locate it, but it's been in our slides for a while. So I'm just going to announce it, but I would strongly suggest before relying on that you get actual guidance from your attorney. And then also, if half or more of the units in a condo are owned by one party that's contracting to provide maintenance or management services to the association in a residential condo, or owned by an officer or director of that corporation, the contract can be canceled by a majority vote of the non-interested unit owners. In other words, if someone buys up most of your community and then contracts with their own company, everyone that has no interest in that, in other words, everyone but that person, gets to vote to say, no, this is garbage. There's absolutely no way we should be allowed to be forced into this contract just because you happen to own more than half the community. And then another one to consider, there are presumed conflicts when you're contracting or proposing a contract with the director or entity directly. Okay, that's another thing to keep in mind. More things that are prohibited in condos are kickbacks. Again, this is part of why we ended up with these statutes, is because, and I'm sorry, I know we have a ton of clients down there, but in Miami, there was a lot of this kickback going on. There was some, pardon me, some going on in Broward County as well, and some in Palm Beach, but for a long time, back in 2015 through 2016, 17, we were getting a lot of reports that we don't really get very often anymore because of these statutes that said that directors, officers were soliciting. In other words, hey, you give me 10 grand, I'll give you this $100,000 contract. I'll make sure it happens. Offering to accept, hey, sure, I'll take this kickback if you want to give it to me, or accepting, thanks for the kickback. Anything or service which wasn't paid for their own benefit or that of an immediate family member. In other words, you can't just say, well, give my son 10 grand so we don't have an issue. From anyone proposing or providing goods or services to the association. In other words, no kickbacks allowed. Now, I want to be clear, as of right now, it is a misdemeanor to accept these kickbacks. It's a crime. In an HOA context, within the next few months, the governor is expected to sign legislation that's going to include a lot of conflict laws in an HOA context. A lot of this stuff is going to be mirrored in HOAs. This is one of the things that will be incorporated, but rather than a crime, there are going to be money damages associated with this type of kickback in an HOA. Now, the only exception to this kickback rule, you can accept food worth less than $25 a person. So, Jeff, in your example, if those tickets were only, the tickets were actually free to the contractor, and the food that's available costs less than $25 a person, which I think that's one hot dog when you go to most of these events.
Yeah, sporting events and movie theaters, it's one hot dog.
Right. So keep in mind, when we're talking about this free food worth less than $25 a person, that basically means you can do Chili's, Applebee's, and maybe one or two other decent places. And then the other thing that you can accept are items received at trade fairs. So Jeff, when you and I were in Tampa a couple of weeks ago and we were handing out,
stress balls,
we were hopefully not throwing them at anyone yet. I know you threw one at me and I accept that. I think I threw it back. But when we're talking about pens,
I'm still recovering, by the way. But, yeah.
Well, they're soft, so it's okay. But when we're talking about the little, I hate to use the word tchotchkes, but that's really what we're talking about. The knickknacks that law firms and a lot of other vendors give out, the bags and things of that nature, as long as it's not like a Coach purse or a nice briefcase, chances are that's going to be absolutely acceptable if it's given as an part of an educational program like this. So if we were to have a seminar in person, like I do in my office every month for HOA or condo board certification, if that was something you were attending, you can have the free pizza that I'm going to offer you because it's less than 25 a person, unless you're eating 2 pies, in which case, hey, good for you. Or, you know, if I decide to hand out pads, which I do at every one of those, and pens so that you have something to write with and on, that's also acceptable. So keep in mind, this is the only exception to this no kickbacks rule.
Where does sponsorships come in? That's always, I'm very curious about that. You go to an event, hypothetical, we're providing a class at a venue, we're having a little spread where, you know, finger foods, that kind of a thing, little snacks, light refreshments. We call it light refreshments. And so is sponsoring the event. Therefore, the firm is not paying for the food or the venue. Does that make a difference?
Well, I mean, technically, I would argue that's an educational program, so it qualifies as the same trade show education.
Okay.
If it was just something that was sponsored, frankly, that's something that I don't know. It may be an issue. You know, it depends whether you're already contracting with them, or if that's a vendor that's, you know, for example, in some of our larger communities or some of the ones that I've worked with that are 5,000 to 10,000 lots, and they're going to throw a, you know, $5,000 party because it might mean that the association is suddenly willing to contract with them. Yeah, I can see that as either a perceived or actual conflict.
Potential. Yeah. And there was a question here, and I know we got to, but what if you win an Xbox at a trade show event, like a CAI event and a drawing? And that's a little different because CAI is not a vendor for hire. They're the ones providing the, that's where the difference is.
They're not a vendor for hire, so no conflict. And just returning, so again, no conflict in that last instance. And returning, again, guys, this is off the cuff, so I'm kind of thinking out loud and thinking further through what you mentioned earlier with respect to an educational program. Unless it's directly to a specific community and it's only the directors attending that educational program, I think it's fine because it's for the entire community.
Yeah.
So if it's incentivizing all of the members to tell the directors, come work with me, it's not a conflict for the directors. So it's not a problem in my perspective.
And that sort of fits in with the sponsorship of a social dance or something at an HOA or a condo where the entire community is welcome to attend and that kind of thing. That makes sense.
Now, where you're hosting the board and the manager, that's where it's an issue. You know, where you say, oh yeah, we'll get a table for 10 and we'll have a party. That's a problem.
Yeah. Okay.
Let's fly through some of the rest because we haven't actually gotten to some of it. So any activity that may be reasonably construed to be a conflict must be disclosed during the relevant board meeting, meaning when it's going to be voted upon and discussed by the board and to the members. So this is where we get into the nitty-gritty. Okay, this is what we need to do when there is a perceived, actual, or potential conflict. I strongly suggest that anyone that has a perceived conflict even discloses it. Now, whether or not you decide to abstain from the voting and discussion, different story. Okay. A rebuttable presumption of a conflict exists if any of the following occurs without prior notice. Now, this is why we're saying give the notice. Okay. If a director, officer, or relative enters a contract for goods and services with the association, clear conflict. Okay. Director or officer or a relative that holds an interest in a corporation, LLC, partnership, LLP, or other business entity that does business with the association or proposes to do business with the association. A proposal. So these are things that can come up where you're being put in a position where there is an automatic conflict unless you can prove that there wasn't one. And the likelihood that you can prove that there wasn't one is generally pretty low. So you want to make sure that you're just disclosing these things. And when I say disclosing, I mean, you know, in the notice, hey, you might want to add the agenda, either the meeting notice, that this particular item, there is a perceived or potential conflict with this director, identify the relationship that they have, and then everyone has knowledge. Everyone gets to vote on, or the board gets to vote, and that individual simply needs to abstain from the discussion and voting. They can still present the fact that this contract is an option. But in order to avoid that imposition of will, so to speak, where you've got one director who's basically looking at everyone around the room and saying, you're going to vote for this, right? Kind of, Jeff, what we discussed before we got started today. Before you're going to have that imposing viewpoint on the rest of the board that is basically forcing everyone into this contract, you give the disclosure, the director or the officer or the manager gets to present just like they would with any other bid for services or goods. And then they have to leave the room so that there is no perception, no actual influence being exerted. Now, another thing to point out, disclosure, termination. Disclosure is the first point, termination is the second. So a proposal for services where there is a where you need to clearly disclose must be attached to the meeting agenda if you have an agenda. Now, keep in mind, within the next few months, HOAs will also need to have an agenda for each meeting, just like condos do. So you can't get away with saying, well, we didn't have an agenda, so we didn't have to attach the documents and all of that. So the corporate not-for-profit statute also needs to be followed. That director needs to disclose the conflict at the board meeting, in addition to attaching the contract to the agenda, when the vote is going to occur, and a sufficient number of votes of non-interested directors, which is 2/3, needs to be obtained. In other words, not only does that person not get to vote, but 2/3 of whoever's left. Now that could be, if it's a 3-member board, that could be literally both people have to vote in favor of it with this person that's stepping out of the room.
So this kind of answers a couple of questions that are on here. One person asked, can a real estate agent also be a board member serving on the board of a condo or an HOA? So that kind of fits in there. You got to disclose everything, correct? And the same thing with another question by a different person. What if a board member also works for the management company that is managing the property? So that also falls into this slide here.
Yeah, I mean, it's, again, I actually am dealing with that situation where, one of the directors happens to work with a management company that I've worked with in the past. And frankly, that's why they decided to work with me. Again, there's not necessarily a conflict there. The conflict would be between the individual and the management company, but you know what? That may be the best management company for them. They just need to disclose the conflict and not vote. That's it. That's literally all that's required when you have this conflict, by the way, is that you disclose it and you don't vote. Now, if you don't disclose it, that's where issues come in. By the way, just to throw in here, another one of those statutory changes that's coming, you'll have to disclose any reasonably construed conflicts 14 days before the vote is taken or the contract is entered in an HOA. It looks like that's going to kick in July 1st. And then also the developer appointed director must disclose once per year at a minimum that they were appointed that way. There's no presumed conflict there, but it's just something that they have to disclose. So the director with the conflict needs to disclose the conflict at the membership meeting, if it's the members voting, where the vote's going to occur on the contract or other transaction, and the membership doesn't vote to terminate the contract. This is the big thing. If that conflict wasn't disclosed and the membership gets to vote, they can just vote to terminate the contract. If the board votes against the contract or service, that interested party needs to notify the board in writing that they won't continue pursuing the relationship. In other words, that conflicted contract. And if they don't do that, the interested director needs to withdraw from office altogether. If they intend to pursue it, they can continue doing that, but not if they're going to remain as a director or an officer. Okay. If the board finds that someone violated this provision, in other words, they didn't disclose or they continued pursuing, they're automatically removed from office. Now, any contract, agreement, or other relationship not properly disclosed is voidable. In other words, the members can vote to say, we don't want this contract. We're done with it. Upon written notice from the board supported by the consent, which means a petition of at least 20% of the voting interests in the association. Now that number may change of how many voting interests is 20% if you've got voting suspensions in place, but generally speaking, it's 20% of your entire membership. And let me step back here. If the disclosure was proper, the contract can be canceled at a properly noticed meeting of the membership by a majority of members in attendance. Okay, so you need a majority of the people that are attending that meeting after you get the 20%. Otherwise, the contract continues in place. Okay, we talked about criminal penalties as a misdemeanor if you violate Chapter 718, Chapter 720's conflict statutes. It's generally going to be money damages. For either, you're probably going to be booted off the board. Any director or officer found in violation of these conflict statutes is removed from the board by the remaining directors. Another way to be removed, and this is all crimes that pertain to the association. If a director is charged by information or indictment with any of these crimes, the director is removed and can't be reelected or replaced on the board, put back, not replaced with someone else, until the charges are dropped or a not guilty verdict is rendered. So this is just a list. We're getting short on time, and I want to do some Q&A for you guys, so we're not going to go through them, but you'll get those slides if you need them later on. All directors, and by the way, it's just crimes that pertain to the association, truthfulness, and the association's funds and property. Just to clarify a little bit. Okay, so all directors, officers, and managers, I mentioned, owe this fiduciary duty. Okay, so these are directors' obligations, legally obligated to do what's in the best interest of the association, according to all Florida statutes pertaining to community associations. So you can't have a do nothing. In other words, I don't vote on anything. I don't care. You don't have a rubber stamp director that says, yep, I'll vote in favor of whatever the board wants. You need to actually engage in the discussion regarding each item and in the voting. Now, keep in mind, you look at abstention. When you abstain from voting, it's not just, I don't like it, along the lines of this do nothing director. I usually don't do that. Sorry about that. It's not just, I don't like what we're discussing and I don't like the option, so I'm not going to vote. You can only abstain from voting as a director, properly abstain, if it is because you have one of these conflicts. Now, I've seen people try to manufacture a conflict to be able to abstain. Listen, I'm not going to sit here and fight you on it, but if your bylaws include a provision that says that people that don't participate in board meetings and board votes are going to be removed from office by the balance of the directors, guess who's the first one on the chopping block? Anyway, focus on the goals of the association, not just the directors. That's what we talked about when we talk about this fiduciary responsibility. You need consistency, uniformity, and timeliness of enforcement. Have policies governing how you're going to enforce your covenants, including collection. Have policies governing how you're going to let members speak at meetings, deal with records inspection requests. And the reason for this is not only to make it easier to figure out what to do next, but almost more importantly, to make sure that people aren't being treated differently from other people in the same community because of some either perceived conflict that someone doesn't like the person that's asking for something, or almost more importantly, because they're just not sure whether the circumstances of this case are different from the circumstances of another one. You got to be uniform the way that you address everything within your community. Otherwise, you're creating defenses for your owners, regardless of any conflict of interest. You got to disclose whenever you're uncertain whether there is a conflict, and again, only abstain from voting due to conflict. So those are some of the obligations. Now we'll move into some warning signs of when there might be a problem that you need to address. Okay, you've got excuses. Well, everyone's taken these funds from these contractors. It's okay. Jeff, we mentioned earlier, I don't know if we mentioned or you and I were just talking about it, but we were talking about the fact that in the near future, we're going to have a huge need, given the amount of communities in Florida and condos in particular, for a lot of vendors, architects and engineers in particular, that are willing and able to perform these reserve studies that are suddenly being required for condo associations.
There aren't enough workers out there right now.
What's that?
Aren't enough workers out there right now. It's a struggle.
There are simply not enough people to do the work. And even though this year's version of the statute is going to allow for teams of people that are led by an architect or engineer to do the work, there are still not enough people to get it all done. So what you're going to end up seeing is the reverse of these kickbacks, where the association's actually basically paying out the vendors. Don't ignore that just because it's common.
Yeah.
Don't do it. Listen, I'd almost rather see an association not getting it done and explaining that the 15 vendors they talked to all wanted an extra 15 grand to get it done within the time that they're allowed. I'd almost rather, and I say almost because I don't want to see anyone getting in trouble, but I'd rather see an association say, well, we couldn't get it done because no one was willing to do the work unless we paid them an extra X amount of money, and then reporting those people back to the powers that be, so to speak. Yeah. Anyway, moving on, since we're down to almost 10 minutes, lack of clear goals and direction. Don't evaluate the competency or the ethical standards based on your budget. Okay, this is something that I harp on when it comes to my board certification class and budgeting classes. Compare your progress to the goals that you have. Compare it to what your declaration and your governing documents require with respect to how you're supposed to be maintaining and operating your community. So just because you want to keep assessments low doesn't mean that you cannot do that reserve study because it's going to cost money. Doesn't mean that you can not repair those stairs in the condo building because it'll cost money. Because you know what? It's going to cost a lot more when you let it deteriorate further and you need even more repairs down the line. And then you're really going to be in it, and you're going to have a lot of members that are pissed off about that huge special assessment that you end up with instead of increasing your maintenance assessments a little bit year by year.
Trying to do more for less always becomes more of a mess.
Agreed. I like that. If someone is refusing or hesitant to obtain professional advice, directors need to understand the rules and the importance of compliance. So we see this a lot, frankly, where people don't want to pay a lawyer. Well, I get that. I wouldn't want to pay me either. But the reality is we get paid because we know this area of law. You don't. Okay. We talk about the certificates versus a board certification class. You can sign a piece of paper that says, I read the governing documents, that's completely meaningless, or you can take a class to try and understand your governing documents from someone like me or someone else within our firm. And frankly, there are other firms out there that'll teach those classes as well. But you want to understand, and you really can't, because frankly, most lawyers don't understand these statutes or your governing documents unless you've got the time taken by a professional to give you legal advice and other types of professional advice. Same with engineers, same with architects. Okay, you really want to make sure that all these things are done right, because otherwise you can end up in a huge lawsuit because the board decided they wanted to save $500 on a legal opinion and end up paying $20,000 in legal fees to defend the association when you screw it up. Disinterest in the members, the directors need to be aware of, it's not us versus them. It's we're here to serve the entire community, including ourselves and the other members. Okay, the directors are there to do the work of the association. It's not the association versus its members. The members legally are not, but in reality, the members constitute the association other than the property and assets. So you want to make sure that you're serving your members, not just serving yourself or doing nothing. And finally, managing some of this risk. Okay, your governing documents should provide for broad indemnification, caveats for improper behavior. In other words, you should be indemnified for anything you do as a director or officer, unless it violates that fiduciary duty. Directors and officers liability insurance, I always say, is your second most important bill. Ours is the first. But it's one of those things you want to make sure to protect people, but not from wrongdoing. If they intentionally do something that they know benefits them to the detriment of others, I hate to say it, but let them rot. Document everything. So we're not going to go through this list, but making sure that everything is properly documented and that you're saving every piece of paper that needs to go in your official records anyway, given that catch-all within the official record statutes for condos and HOAs. And then finally, I mentioned directors and officers, but get adequate insurance coverage for liability and casualty as well. Make sure that you're going to be covered for whatever goes wrong in your community, because that's one of the ways to protect yourself, including from a director who does something wrong. Okay, general best practices. We talked about requiring board engagement. I talked about, you're limited in your delegated authority. The president can't just go off on his or her own and sign contracts without talking to the board first and getting a vote, etc. You might also have dollar figure limits on what directors are allowed to do without a written document authorizing that expenditure. Competitive bidding on a periodic basis, including for all of your contracts other than the ones that are not up for another 3 years. And by the way, you should be limited in how many of those 3-year contracts you're even willing to consider. Create goals and an action plan I talked about earlier, requiring advanced and annual disclosures from your directors. That includes also employees and your manager as to what's going on in the community, what they've been doing, and the pluses and minuses that they've seen throughout the year. Always use licensed and insured contractors, because if they are working on your property and something gets damaged, whether that's common areas, another unit, another lot, or frankly, someone gets hurt on the job, you want to make sure you're covered. That includes workers' comp. My partner, Jeff Rembaum, one of the named partners of the firm, just wrote an article last month in Rembaum's Roundup about how important it is to make sure that all of your contractors have workers' compensation coverage, because if one of them gets hurt and can't work, guess who's footing the bill otherwise? It's the association. And then finally, require detailed reviews and accounting oversight. Also require all your directors to get board certification, not just sign a piece of paper that says, I read the declaration and bylaws, I don't know what the hell they say, but I'm going to do my best to uphold what's in them. So that's it for the day. We'll move on to our Q&A. Jeff, I know we only have a couple minutes. I will take a couple extra minutes and I will stop my screen sharing. If you want to kind of do your thing like you usually do, I'd appreciate it. And just kind of filter through the chat, the Q&A, some of the more salient ones that we didn't really touch on quite as much. I know that you're limited in how quickly you can read, but if you can get the ones that we already went through, that'd be good, because we are limited in time and we've got 23 in the chat or in the Q&A and 7 in the chat. So if you want to start, I will stop my sharing and get back on screen full time.
Yeah, here's one that is very related, touched upon briefly earlier, and I think I already know the answer. But let's just clarify. Under a circumstance like this, our board is actually appointing a realtor, and I'm assuming this person means appointing a realtor to the board of directors today.
Okay.
Our board does approve members, but this person will not be part of the screening or interview of any properties she sells. Is this okay? And I would assume it probably is.
Should be doing. That's exactly what they should be doing. If they're not going to be part of that process for anything that involves their, frankly, you might want to go one step further and go to anything involving their brokerage, not just them personally.
Okay.
But I wouldn't say that's necessary and required, but it might be something to do just for disclosure purposes and transparency purposes.
Yeah. And if you could eliminate conflict, why not do it?
Right.
This is an interesting question, and this proves my point that no matter how bad the economy is, no matter how dire a situation is, people will not skimp on entertainment and recreation and activities. So here's a question. If it's a job like a DJ at a condominium event, can a board member get paid I'm assuming if he or she is going to be the DJ?
That person can perform services and be paid for those services outside their directorship. It's just the same situation. It is a conflict, but that person just needs to disclose, hey, I'm the person that might perform these services. I'm proposing these services to the association. And once I get through my spiel of, hey, here's why I'd be a good fit, I walk out of the room, the board gets to discuss and vote without me there interfering with that vote. That's it. But yes, it's absolutely allowed. But again, just like any other conflict, potential contract, potential goods and services that you're potentially contracting for, you just step out of the room when the discussion and voting is happening.
Okay. This one, if a property manager is a general contractor as well and never disclosed it to the board and pushes his or her company to get all of the projects, can something legal be done I guess, to that property manager, or who would face the repercussions of something like that?
I'm glad no names were named. The repercussions would potentially be faced by the property manager, potentially their employer if they're with a management firm. The first step would be to point out that this is happening potentially to that person's supervisor, if that person's supervisor exists. But the reality is the DBPR does govern management firms and managers, and that's probably who you'd want to report this to. Whether or not that's going to actually benefit your association, probably not. The other thing to consider is what the management contract calls for. Most of them, including, I believe, the Florida statutes, create a fiduciary duty, just like a director would have, for the association and the manager. So that might be a breach of fiduciary duty. Now, the question is whether or not you were damaged by it. If that contractor would have been the best vendor, even though it's the same person as your manager, that might not qualify as any damages to the association.
Yeah.
It would just be, again, like I mentioned earlier, not all conflicts are bad. Now, the lack of disclosure is 100% bad, but it may not really be a problem. So that's one that you'll want to run by your attorney and discuss in depth, rather than relying on guidance that's just educational in theory only that you're getting today.
Alan, how much more time do you have? Because I do want to go over the evaluation process one more time before people need to jump off.
Another 5-10 or so.
Okay. Let's do one more question, then I'll do the evaluation, and then we'll go to a few more questions. Sound okay?
We do another question. I know you wanted to mention that Danielle's got a great class coming up in 2 days. So let's just throw that out there real quick.
Yes. On the 25th, on the 25th, we have, and on kbrlegal.com, this is something that, because it's such a hot topic, we have a course all by its lonesome for this. It's navigating the FFHA assistance animal or pet, and that is 11:30 a.m. Eastern on this Thursday with Danielle Brennan from our Palm Beach Gardens location. You won't want to miss that. I'll put that link into the chat as well, because we did have a question in the Q&A about assistance animals, but this course is not pertaining to that. So we won't get to that one today, but I just put the link into the chat if you want to register for that. Thanks for reminding me.
Sure.
And a board president who also happens to be, this is kind of specific, but we won't mention names or associations. Can a board president who is also a wealth management advisor move his or her condo's money to invest with a brokerage firm? I guess that person's brokerage firm.
I mean, the conflict is there. It's obvious. It's a matter of whether that person has disclosed the relationship, which, presumably if you know about it, it's a matter of whether it was disclosed to the members as a whole.
Right.
And whether they stepped away from the decision being made. Now, if they unilaterally did that, that's a big problem. If it was just a board decision that was made with that person stepping out of the room, I don't see it as a problem. It is a perceived conflict, but again, and frankly, an actual conflict. But if they disclosed it properly and did the right things, it might be okay.
Cool. Board member. What if a board member, okay, this is an interesting one. And this one kind of hits home for me, because I used to, for those of you who know me, I used to be part of a team, the administrative team of one of the larger 55 and over properties. What about if the master association board members hire a management company that they are using for their own separate building association within the master? This would include knowing all of the financial matters. So is it a conflict if the same management firm is going to be hired for the master as well as for some of the individual associations within the master?
So that's a perceived conflict, and it's one that I've dealt with twice in the last 3 months, actually, where there's a master and a sub, and the master has a management company, and you've got several people on the boards of both entities, and you're using the same management company. I don't know what the politically correct term is, so I will just say that management company is legally obligated to keep a wall between one community's data and the other community's data. They cannot look at the same, even if it's the same manager, person, individual, that is able to look at one versus the other. That manager is legally obligated not to share information with the other one unless it is something to which the other one is actually entitled. If the manager does share that information without authorization, like I said, that's something that potentially gets reported to their governing body, gets, potentially results in a lawsuit for breach of the contract, breach of fiduciary duty, etc. But that's one that, if it becomes an issue, I would run it by your attorney, but in reality, I don't see that as an actual conflict, because management most likely has separate login credentials for each community. And so it's not, information shouldn't be shared between one and the other unless it's supposed to.
Makes sense, especially with the different login creds.
Right.
I think you just answered this. How do we file a complaint to the state regarding these issues that were talked about today that are not being handled properly, aside from going to your association council? What are some other things that associations can do?
The free option, so to speak, is to go to the website for the corporate entity, I'm sorry, the government entity that deals with property managers, community association managers. So if you just Google Florida Community Association Manager, I think one of the first 2 or 3 links is actually to the governing body, which I believe to be the DBPR. And there should be a link somewhere on their website that says basically file a complaint.
Okay. Let's do a couple more. I know you got to run. What if a board member is leasing dock space? Is he or she allowed to vote on any other types of any dock space decisions, or any dock decisions in general?
The question then becomes, if we're saying that the person is leasing space to the association, or is leasing space that happens to be adjacent to the association, and the answer to that is going to dictate how that gets dealt with. If the person is leasing the space to the association, then obviously that's a conflict that needs to be disclosed. They don't get to vote. They don't get to discuss when the board is discussing it. But beyond that, I don't see it as an issue. If they don't own the property and they're leasing a specific dock space from the association or from some other entity adjacent to the association, there's no conflict, because the director's not the one that's doing anything other than, just as any other member would presumably be entitled to do, is renting a space. It'd be like renting a parking space at that point, or you've got the right to park in a space. If you happen to park closer than everyone else and you're not assigning yourself that closer space, where was the conflict?
Yeah. And folks, I'm skipping a lot of questions. And the reason I'm skipping a lot of these questions is that they fall into what Alan mentioned earlier, that as long as you disclose that you're involved with the association somehow and you provide a service, as long as you disclose it, you should be okay. So I'm skipping a lot of these questions that fall into that, under that umbrella. Let me see here. So that's why I'm struggling to find some unique questions here, because so many of them are so darn similar with scenarios that all would be required is to just let people know who you are and what you're doing.
Yeah, I hate to be so general about that, but the reality is, in 99% of circumstances that are going to come up, I'm trying to think of one that wouldn't be properly addressed that way, and nothing comes to mind. It would have to be something really egregious where you didn't disclose it, and that's really the issue, is that you need to disclose.
Yeah.
Biggest issues that I see coming up are where people didn't bother to say anything and they're hugely benefiting. Or like we said, the kickbacks, which are always going to be under the table, so to speak, things of that nature.
Some things that people can do too is like on the Florida SunBiz website, because I know there were some situations. There's one question here. There's some situations where you look up different companies and they all seem to be the same person. And those are the kinds of things you can look up on websites like Florida SunBiz and see who the listing agents are with regards to any companies, to help avoid conflicts too.
And just to mention, in addition to that, not just searching by the corporate entity that you may be working with, but, to the extent that people think that there are directors doing shady business, frankly, you can search by name as well, and it'll disclose whether that individual is an officer or director of any corporation throughout the state.
That's exactly right. You could look up condos, HO, any association you could look up, because they are corporate entities. Can roommates, and I guess this also means husband and wife, boyfriend and girlfriend, or just strictly roommates, can they serve as president and VP on a board in an HOA or a condo, or essentially on a board period? Can people who live together serve on the same board?
So there is a prohibition, and I think it's condo specific. It may be HOA, and obviously this is not one of the things that we prepared for today. So I don't recall offhand, but there is
different kind of conflict. That's true. Yeah.
Yeah, the husband and wife is the only one where you're not allowed to serve together unless there's no one else that wants to serve. but again, I don't recall whether it's condo or HOA. I think it is condo, and it's also, I think, with respect to only certain sizes. I think it's more than 15 units or something like that where it applies, because if you're less, then you might just not have people interested. But again, that's only husband and wife. So if it is, I mean, I could see it being extended to same-sex spouses,
Domestic partnerships, that kind of a thing.
just a roommate, whether you're romantic involved or not, a girlfriend, boyfriend, son, daughter, none of that is expressly stated anywhere in Florida law. So unless your bylaws say that, you know, people from the same lot, same unit can't serve on the board together, it's probably just fine.
Let's go to two more and then we'll let you get out of here. And these are different than the questions that have been coming in. Sometimes a board member or a resident, and I guess by using the word resident, that could also mean a renter. So be careful which words you use, a board member or an owner. I'll say board member or owner instead of saying board member or resident. So if sometimes a board member or an owner will do a small repair or cleanup for no pay, but just for the cost of any products needed for reimbursement, is that okay?
As long as they're not using an association debit card to pay for it, which is something that's not generally allowed, that's totally fine. That reimbursement is also totally fine, as long as it's the actual cost, presumably including that individual, whether it's a resident or the director, actually giving receipts for what they paid to get reimbursed.
Okay.
So that there's some backup to show that the proper amounts were paid. Now, obviously, there's still the chance that someone asks for reimbursement for things that they didn't use for the association. But that's the best way I can think of to protect yourself there. Or to authorize it in advance of the work being done and specify, here's what we have gotten from other contractors, this is what we'll pay you.
Okay. Alan, great class. There's still a bunch of questions on there. And as we said in the beginning, with 300 something people here, there's no way we'd get to all the questions in the time. So what we're going to try to do is we're going to try and get some of these questions answered in an after show, similar to what you see with some of these nerdy YouTube shows, which I love, about movies and music. They do an after show with the Q&A. So we'll do something similar and we'll email everybody when it's completed. Sound okay with you?
Yeah, sounds great.
I think it'd be fun. And so I know you got to get out of here. I'll stay on board for a little bit longer. Alan, before you go, how can everybody reach you, especially if they're in the Orlando area and would like one of the best association attorneys and firms to help them out?
Sure. Thanks, Jeff. So the easiest way to reach me is my nice and easy email. It's Alan Schwartzide at KBR Legal, our website, kbrlegal.com. So again, as@kbrlegal.com, or you can call any one of our offices. If you call the Pompano office, it'll get through to literally anyone in the entire firm. And that number is 954-928-0680. Jeff, thank you as usual for moderating and moderating me as well, making sure that I didn't go off the rails too far. And to everyone that's still on and everyone that attended, thanks so much. And I really hope you got a lot out of it. Feel welcome to reach out to me anytime if me or our firm can help you out. And again, whether it's me or someone else in the firm, you know, we all work together. So the good news is if you're anywhere in the state, we can help you out.